Welcome once again to Kairu Know Your Rights University. In the name of Allah the Beneficent, the Merciful, I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Back at you once again with another video. Today we're going to be reading from case law concerning due process rights. Let us begin. It's from the Seventh Circuit Court of Appeals. The case is called Robert Gotcho versus Anthony Wells. Robert Gotcho is serving a life sentence for the 1982 kidnapping and unaliving of Aldo Fratto and Tullio Infelice. Cook County Circuit Judge Thomas Maloney presided in his case. Maloney was corrupt. For years, he lined his pockets by soliciting cash for acquittals. To deflect attention and up the ante for bribes, he came down hard on defendants who could not or would not pay. Maloney's corruption was exposed in 1991, and he was sent to federal prison. Gotcho has been pursuing state and federal collateral relief ever since. Gotcho was charged and tried jointly with co-defendant Dino Titoni, though the latter waived his right to a jury verdict and opted for a decision from the bench. The reason became clear later. Titoni paid Maloney $10,000 for an acquittal, but as federal investigators began closing in, Maloney reneged and found Titoni guilty. The jury returned a guilty verdict against Gotcho. After Maloney was indicted, Titoni won a new trial based on judicial bias, but Gotcho's post-conviction proceedings dragged on for decades. In 2016, the Illinois Appellate Court finally resolved his claims and denied relief. As relevant here, the court rejected his due process claim based on Maloney's corruption. The court held that Gaucho needed to prove that the judge was actually biased against him and had not done so. A district judge reviewed that decision under 28 U.S.C. Section 2254 and denied habeas relief. We reverse. The Due Process Clause secures a right to trial before a fair and impartial judge. Evidence that the presiding judge was actually biased is sufficient to establish a due process violation, but it's not necessary. Constitutional claims of judicial bias also have an objective component. The reviewing court must determine whether the judge's conflict of interest created a constitutionally unacceptable likelihood of bias for an average person sitting as judge. Caperton versus A.T. Massey Coal Company. The state court cited Caperton but ignored the objective test, holding that Gaucho's failure to establish actual bias was fatal to his claim. The ruling was contrary to federal law as explained in Caperton. So we review the claim without deference to the state court. We hold that the acute conflict between Maloney's duty of impartiality and his personal interest in avoiding criminal liability created a constitutionally unacceptable likelihood of compensatory bias in Gaucho's case. The judge took a bribe from Gaucho's co-defendant and promised to rig the joint trial in his favor, then reneged to evade detection. Under these circumstances, Gaucho, no less than Titoni, was deprived of his due process right to trial before an impartial judge. He is entitled to habeas relief. Background. The history of this case spans almost 4 decades. We trace the background when Gaucho's habeas proceedings were last before this court. Additional detail can be found in the Illinois Supreme Court's decision on direct appeal. For present purposes, a summary will suffice. On the morning of December the 12th, 1982, a DuPage County Forest Ranger spotted a parked car in a remote area near the Des Plaines River. As the ranger approached, he heard pounding coming from inside the trunk. He summoned the police and together they opened the trunk, finding Fratto and Infelice inside, both bound, and shot multiple times. Frato was unalived and Infelice was barely conscious. When the ranger asked Infelice who did this to him, he replied, Robert Gott or Gotch, Dino, and Joe. Infelice, unalived of his wounds about 2 weeks later. Gaucho was arrested and confessed. Together with Titoni and Joe Sorrentino, he was charged in Cook County Circuit Court with kidnapping, armed robbery, and double unaliving. Gaucho moved to suppress his confession, claiming that the police beat him and ignored his request for counsel. The motion failed. That motion failed. In addition to the confession, the prosecution's case included testimony from Gaucho's girlfriend, who had witnessed the key events. The case against Sorrentino was severed, but Gaucho and Titoni were tried jointly in Judge Maloney's court. The proceedings had an unusual twist. The charges against Gaucho were submitted to the jury, but Titoni waived the jury verdict and requested a decision from the bench. Both men were found guilty and sentenced to unaliving. The Illinois Supreme Court vacated Gaucho's unaliving sentence, and on remand, he was sentenced to life in prison. As the world now knows, Judge Maloney was corrupt. The Operation Greylord undercover investigation caught Maloney in a long-running shakedown. Throughout the 1980s, he solicited and accepted bribes to fix cases. In 1991, a federal grand jury indicted him on racketeering and extortion charges. He was convicted in 1993 and sentenced to a 15-year term in federal prison, Bracy versus Gramley. See also United States versus Maloney. He died in 2008, not long after his release from custody. Maloney's willingness to take bribes for acquittals had a sinister flip side. To deflect suspicion from his criminal scheme and give defendants an incentive to cough up bigger bribes, Maloney built a reputation as one of the most ruthless judges on the Cook County bench. We detailed his propensity to engage in so-called compensatory or camouflaging bias in our decision in Bracy versus Skolnick. Bracy involved a different unaliving case in Maloney's court, but we discussed the judge's misconduct in the Titoni case and the effect of camouflaging bias, explaining that Titoni gave Maloney a $10,000 bribe, but Maloney convicted him anyway, and that a state trial judge later vacated Titoni's conviction because Maloney had a motive to convict Titoni to deflect suspicion from himself. Meanwhile, Gaucho, the man sitting next to Titoni at trial, also sought state collateral relief, but the proceedings moved at a glacial pace. He filed a pro se post-conviction motion in 1991, soon after the indictment against Maloney was unsealed. Among other claims, he alleged a due process violation arising from Maloney's corruption. He also asserted that Daniel Radakovic, his attorney, pressured him to raise $60,000 to bribe Maloney, but he was unable to come up with the money. Gaucho amended his petition through appointed counsel in 1997 and again in 2008. The Cook County Circuit Court dismissed Gaucho's petition in 2009, but the Illinois Appellate Court reversed the dismissal of the judicial bias claim and remanded for an evidentiary hearing. The hearing focused on Maloney's bias. Gaucho testified about Radakovic's recommendation to bribe Maloney. He also submitted affidavits from his mother and aunt, both now deceased, stating that Radakovic had approached them about raising money for a bribe. Gaucho testified that when he and his family were unable to come up with the money, Radakovic became disinterested in his case. Radakovic, testifying for the state, denied having any conversation with Gaucho or his family about a bribe and asserted that he was actively involved in Gaucho's defense. Gaucho also presented evidence that Titone bribed Maloney. In an affidavit, Titone's father stated that he paid Maloney $10,000 to fix the case. He also stated Judge Maloney was coming up for an election for judicial retention in the fall of 1984. Dino Titone's attorney said that as long as Maloney got 2 out of the 3, it would be enough. This meant that as long as my son's 2 co-defendants, Robert Gaucho and Joe Sorrentino, were found guilty, Judge Maloney could get away with letting Dino go free, and Judge Maloney could still get elected. Following the hearing, the judge credited Radakovic's testimony, discredited Gaucho's, and denied relief. The Illinois Appellate Court affirmed. The court deferred to the post-conviction judge's refusal to credit Gaucho's testimony that Radakovic proposed bribing Maloney to fix his case. The court accepted, however, that Titone bribed Maloney, citing Bracey and United States ex rel. Titone versus Stearns. With that factual premise in place, the court addressed Gaucho's claim of compensatory judicial bias. The court noted Caperton's objective standard, but did not apply it, holding instead that a claim of compensatory bias requires evidence that the judge was actually biased in the defendant's own case. The court explained that the post-conviction judge had considered the possibility that Maloney compromised Gaucho's rights during the trial, but could not find one questionable ruling, and that Gaucho had failed to bring any questionable ruling to this court's attention. Finding no evidence that Maloney was actually biased against Gaucho as a result of the bribe from his co-defendant, the court rejected the claim. The Illinois Supreme Court denied review. Gaucho sought habeas review under Section 2254. He raised 18 claims, including a due process claim based on Maloney's corruption. In a lengthy opinion, the district judge rejected each one. Regarding the judicial bias claim, the judge concluded that the state court's application of an actual bias requirement, though questionable, was not contrary to or an unreasonable application of federal law. See Section 2254D. The judge denied relief across the board but granted a certificate of appealability on the judicial bias claim. Gaucho appealed, and we appointed counsel for him under the terms of the Criminal Justice Act, 18 U.S.C., Section 3006A, A2B. Discussion. Federal court review of state convictions is limited in scope. Section 2254D1 provides that a federal court may not grant habeas relief on any claim that the state court has adjudicated on the merits unless the state court's decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. As relevant here, a state court's decision is contrary to clearly established federal law if it applies a rule that contradicts the governing law set forth in Supreme Court cases. Brown versus Payton. If a state prisoner surmounts the high bar set by Section 2254D1, then we review his claim de novo under the traditional habeas standard, asking whether he is in custody in violation of the Constitution or laws or treaties of the United States. Section 2254A, Mosley versus Atchison. Due process and the conflicted judge. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. One more time. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. Caperton at 876, quoting in regards Murchison. Most judicial conflict of interest issues are governed by standards set in state and federal disqualification statutes and judicial codes of conduct, but the Due Process Clause sets a constitutional baseline. See United States Constitution Amendment 5 and Amendment 14, Section 1. This case turns on the distinction between the subjective and objective components of the framework for evaluating the constitutional implications of judicial conflicts of interest. The central question is this: must a litigant prove actual bias to establish that his trial before a conflicted judge violated his right to due process, or does the doctrinal test also entail an objective inquiry? The Supreme Court's decision in Caperton marked a watershed in this body of constitutional law by making clear that testing for actual subjective bias is not the end of the inquiry. The imperatives of due process require application of an objective standard in all cases, whether or not actual bias exists or can be proved. To understand Caperton's significance, it's useful to step back and trace the decades of case law leading up to it. Before Caperton, the court had historically recognized two categories of cases in which a risk of bias, rather than actual bias, triggered constitutional scrutiny. The first category comprises the pecuniary interest cases, adjudications by judges with a financial interest in the outcome. The earliest case of this type, Toomey versus Ohio, involved a small town mayor who was authorized to preside over trials for unlawful possession of alcoholic beverages and received a salary bonus for each conviction, with the funds coming from the fines he imposed and the balance going into the municipal fisc. This arrangement, the court observed, created an official motive to convict and to graduate the fine to help the financial needs of the village. The court explained that the Due Process Clause incorporates the common law principle that a judge with a direct, personal, and substantial pecuniary interest in a case is disqualified from hearing it. Extrapolating from this principle, the court held that the mayor judge's direct pecuniary interest in the outcome of the cases, more specifically his pecuniary interest in convictions, violated the due process rights of persons who came before him accused of alcohol possession violations. This was so whether or not the judge was actually biased. There are doubtless mayors who would not allow such a consideration as $12 costs in each case to affect their judgment in it. But the requirement of due process of law and judicial procedure is not satisfied by the argument that men of the highest honor and the greatest self-sacrifice carry it on without danger of injustice. Every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. Every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. One more time. Every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. Since Toomey, the court has expanded the understanding of what it means to hold a direct, substantial pecuniary interest in the outcome of a case. For example, in Ward versus Village of Monroeville, The court considered a mayor-judge scheme similar to the one at issue in Toomey, but minus the salary supplement. The court began by explaining that the absence of a personal pecuniary interest did not change the analysis. The fact that the mayor and Toomey shared directly in the fees and costs did not define the limits of the due process principle. Rather, an unacceptable temptation to convict may also exist when the mayor's executive responsibilities for village finances may make him partisan to maintain the high level of contribution from the mayor's court. This, too, the court held, is a situation in which an official perforce occupies two practically and seriously inconsistent positions, one partisan and the other judicial, and necessarily involves a lack of due process of law in the trial of defendants charged with crimes before him. Quoting Toomey, the court went even further in Aetna Life Insurance Company versus Lavoie. There, a justice on the Alabama Supreme Court was a plaintiff in two lawsuits against insurance companies alleging bad faith failure to pay claims. One suit was brought as a proposed class action, and both sought punitive damages from the insurers. While the suits were pending, the justice cast a deciding vote in favor of the plaintiffs in a case raising nearly identical legal issues about insurers' bad faith failure to pay claims. The Supreme Court held that the justice's role as a plaintiff in a highly similar case gave him a direct, personal, substantial, and pecuniary stake in the case before his court. The court emphasized that it was not necessary to decide whether the justice was in fact biased, but only whether the conflict of interest would offer a possible temptation to the average judge to tip the balance in the plaintiff's favor. Applying this subjective test, the court held that the justice's participation in the case violated the insurer's right to due process. The second set of cases in which charges of judicial bias traditionally raised constitutional concerns includes those in which the conflict arose by virtue of the judge's prior participation in the proceedings. Murchison, 349 U.S. 133. The so-called one-man grand jury case is an example. There, a judge sitting as a secret judge grand jury, a procedure permitted by state law, interrogated two witnesses, charged them with perjury and contempt, then tried and convicted them. Applying Toomey, the court needed only a few short paragraphs to reject this procedure as inconsistent with the requirements of due process. Such a system, the court reasoned, violates the principle that no man can be a judge in his own case. The court concluded a fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of cases, but our system of law has always endeavored to prevent even the probability of unfairness. But our system of law has always endeavored to prevent even the probability of unfairness. One more time. But our system of law has always endeavored to prevent even the probability of unfairness. See also Mayberry v. Pennsylvania, holding that a judge who charged a litigant with contempt for salacious personal attacks could not preside over the litigant's contempt proceedings because no one so cruelly slandered is likely to maintain that calm detachment necessary for fair adjudication. Each of these cases applied an objective standard, though it was phrased in a variety of ways. In Toomey, the court focused on the possible temptation to bias. In Murchison, the court examined the practical difficulty of remaining free from bias. In Mayberry, the court considered the likelihood of a fair adjudication. Regardless of how the standard was phrased, proof of actual bias was not required. Caperton versus A.T. Massey Coal Company. That's where things stood before Caperton. Courts debated whether the objective inquiry applied broadly or was limited to pecuniary interests in criminal contempt cases. Compare Raleigh versus Webb, describing the probability of bias rule as limited to only two, perhaps three, very specific situations, and Crater versus Galaza with Jones versus Lubers, applying Toomey's and Murchison's potential for bias rule, generally including to an allegation that a trial judge's feud with a public defender created an unconstitutional risk of bias, and Bracey, Rovner, Judge, concurring in part and dissenting in part, proposing that Toomey, Murchison, and Lavoie support applying an objective possibility of bias approach to compensatory bias claims. Caperton settled the debate, making clear that the objective standard applies uniformly as an implementing doctrine for the constitutional guarantee of due process. Caperton settled the debate, making clear that the objective standard applies uniformly as an implementing doctrine for the constitutional guarantee of due process. One more time. Caperton settled the debate, making clear that the objective standard applies uniformly as an implementing doctrine for the constitutional guarantee of due process. The specific conflict of interest at issue in Caperton raised a question unique to elected state judiciaries. When, if ever, does an elected judge have a due process obligation to recuse himself because of campaign contributions? The facts of the case placed the problem in sharp relief. The plaintiff, Hugh Caperton, won a $50 million judgment against A.T. Massey Coal Company as the coal company's appeal wound its way to the West Virginia Supreme Court. CEO Don Blankenship created an independent political action committee to defeat an incumbent justice and elect his challenger. Blankenship contributed $3 million to that effort, which dwarfed the total spending by the campaign committees of both candidates combined. The investment paid off. The challenger, Brent Benjamin, was elected. Caperton moved to disqualify the new justice, arguing that recusal was required under the Judicial Code of Conduct and as a matter of due process. Justice Benjamin denied the motion. The state Supreme Court eventually ruled for the company and reversed the $50 million verdict, with Benjamin casting the decisive vote. The Supreme Court reversed, holding that Justice Benjamin's participation violated Caperton's right to due process. After surveying its due process cases regarding conflicted judges, the court explained that constitutional claims based on judicial bias have both subjective and objective components. The existence of actual bias, of course, requires recusal as a matter of due process, but the subjective inquiry is just one step in the judicial process. Objective standards may also require recusal whether or not actual bias exists or can be proved. Mapping the objective test onto the campaign contribution question, the court held that due process requires an objective inquiry into whether the contributor's influence on the election under all the circumstances would offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. Applying that standard to the case at hand brought two key facts to the surface. Blankenship's enormous monetary contribution had a significant and disproportionate influence on Justice Benjamin's successful campaign, and the coal company's challenge to the $50 million judgment was then pending and soon would be before the state Supreme Court. This combination of circumstances created a serious objective risk of actual bias that required Justice Benjamin's recusal. It did not matter that Justice Benjamin had conducted a probing search and concluded that he was not biased. We do not question his subjective findings of impartiality and propriety, nor do we determine whether there was actual bias. Instead, the court emphasized the need for an objective test, the difficulties of inquiring into actual bias, and the fact that the inquiry is often a private one simply underscore the need for objective rules in lieu of exclusive reliance on that personal inquiry or on appellate review of the judge's determination respecting actual bias. The due process clause has been implemented by objective standards that do not require proof of actual bias. The due process clause has been implemented by objective standards that do not require proof of actual bias. One more time. The due process clause has been implemented by objective standards that do not require proof of actual bias. In defining these standards, the court has asked whether, under a realistic appraisal of psychological tendencies and human weakness, the conflict of interest poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of due process is to be adequately implemented. Quoting Withrow versus Larkin, in the end, the court stated its rule broadly and bluntly. The failure to consider objective standards requiring recusal is not consistent with the imperatives of due process. The court emphasized the circumstances in the case were extreme by any measure, adding that the objective constitutional standard does not displace codes of conduct and disqualification statutes as the primary sources of rules for most conflict of interest questions. Because the codes of judicial conduct provide more protection than due process requires, most disputes will be resolved without resort to the Constitution. Still, extreme cases are more likely to cross constitutional limits, requiring this court's intervention and formulation of objective standards. This is particularly true when due process is violated. The Illinois Appellate Court's decision and Section 2254. The Illinois Appellate Court acknowledged Caperton but declined to apply the objective standard. Instead, the court concluded that the Supreme Court's decision in the Bracey litigation controlled. Moreover, the court read Bracey to require proof of actual bias in all claims of compensatory bias. That ruling was contrary to both Caperton and Bracey. First, as we have already explained at length, Caperton announced a general rule. Due process claims based on judicial bias require an objective assessment of the likelihood of bias, not just a subjective assessment of actual bias. So the Illinois Appellate Court didn't follow the federal law and guidelines set forth by federal cases such as Caperton. Due process claims based on judicial bias require an objective assessment of the likelihood of bias, not just a subjective assessment of actual bias. Nothing in the court's opinion suggests that it was limiting the application of this rule to campaign contribution cases. To the contrary, the court's reasoning rested largely on concerns about the administrability of a rule requiring proof of actual bias. And those concerns are present in all cases. Second, the state court's reading of Bracey was mistaken. True, Bracey involved a claim of compensatory bias in another case tried in Judge Maloney's court. William Bracey alleged that Maloney engaged in camouflaging bias in his case to conceal his bribes in other cases. The issue before the court, however, was quite narrow. The case concerned only whether Bracey had made an adequate preliminary showing of Maloney's bias to establish good cause to take discovery on his claim. The court held that he had done so and was entitled to discovery. In other words, the court's discussion of actual bias made sense in context because Bracey had supported his discovery request with some evidence of Maloney's actual bias in his case. Bracey thus stands for the unsurprising proposition that evidence of actual bias is sufficient to establish a due process violation, but it does not follow that actual bias is a necessary condition for relief. That is, the court was not silently limiting Toomey, Murchison, and other cases that applied an objective risk of bias standard. It had no reason to address the objective standard because the facts at hand suggested more. For all reasons, Gacho has satisfied Section 254D. The state court's decision was contrary to federal law as established by the Supreme Court in Caperton and Bracey. We therefore review his claim de novo, applying the objective standard. We ask whether the average judge in Maloney's position is likely to be neutral or whether there is an unconstitutional potential for bias. Judicial bias claims are not subject to harmless error review. So Gaucho is entitled to relief if the judge's conflict of interest created a constitutionally intolerable likelihood of compensatory bias in his case. We begin with the obvious and important observation that Titone's bribe cannot be separated from Gaucho's case. Everyone accepts that Titone did not get a fair trial because of the bribe, yet the state asks us to conclude that the same judge ruling on the admissibility of the same evidence, presiding over the examination of the same witnesses, and imposing sentence on both defendants could have been neutral in Gaucho's case. That defies practical reason. Any decisions Maloney made in Titone's case based on his desire to deflect scrutiny from the Operation Greylord investigators would necessarily affect Gaucho too. It is irrelevant that Gaucho was convicted by a jury rather than Maloney himself. Catalino versus Washington, holding that an opportunity for impartial appellate review does not excuse the trial judge's bias. No reasonable person could accept that Maloney would be neutral in the joint trial after he accepted a bribe from Gaucho's co-defendant and then reneged on the deal out of self-preservation. To be sure, Caperton emphasized that the due process line is crossed in only extreme cases, but Maloney's bribery scheme was at work in this very case, so the circumstances can fairly be called extreme. Maloney's dereliction of duty casts an unusual light and makes it hard to put Maloney in any normal framework. We're satisfied that the likelihood of compensatory bias was too great to be constitutionally tolerable. Accordingly, Gaucho was deprived of his due process right to be tried before a fair and impartial judge. We reverse the district court's judgment and remand with instructions to grant the writ. This concludes our reading of this case. We hope that it has been informative and educational, as well as, if any, benefit to you. We thank you once again for tuning in to Cairo, Know Your Rights University. Until next time, peace and blessings to you all.